It really is troubling to have the Court of Appeal hand down a judgment which, to so many people across the country, appears on the face of it to be heavily swayed by policy and politics. I'm not going to comment on the background of the judges and what positions they've held in the past, which has led to many people thinking that they've been swayed in some way. I'll leave that to commentary of other people. That's nothing to do with me. But I do now have the benefit of the judgment in front of me, so I'm going to point to you to paragraphs where I think it's not only contradictory, but it actually spells out that it is doing the thing that it really shouldn't do. But also, I've been criticised for not giving an overview of what this is all about for those of you that are not familiar with it. In very short, there was a migrant hotel in Epping, and the Council of Epping sought an injunction to have it closed to say that they're in breach of planning law. And therefore, if there was an arguable case for breach of planning regulations, that they sought an injunction to prevent the continuance of that, and therefore an interim injunction to have the hotel emptied. The judge at the High Court did grant that, and they were to be removed by the 12th of September. Then the Home Office at the last minute jumped in and said, well, actually, we would like a say in this because where else are we going to put them? They did say, the Home Office did say, well, we are going to move them out eventually somewhere else, which is a completely different issue to whether they've broken the law of planning regulations. And so the Home Office jumped in. Now the Court of Appeal has ruled that, in fact, yes, we'll consider all these things. The Home Office can jump in. We're going to set aside the interim injunction, and the full hearing will go ahead in October. So that out of the way, if you do like an overview of the law here, please do subscribe to the channel. Help me on my mission to 1 million subscribers, and I'll be really grateful. So let's go to the judgment and why I think it's contradictory. Paragraph 35 sets out, well, the court sets out what it is not allowed to do and what it is allowed to do, what it is to do in this judgment, in being asked to set aside this decision. Paragraph 35, it said, is not open to this court to set aside the exercise of the judge's discretion simply because the three of us would have exercised it differently. Now, just a point on that, this is one of the bone of contention that lots of people have with judges' decisions, judgments, if you like. They make a judgment call. Now, one of the rules of appeal is not to say, well, I disagree with what the judge found, and therefore I think it should be a different result. That is not a ground of appeal. It's only a ground of appeal if there's an error of law or an error of procedure, or in an equitable remedy such as this, such as an injunction, either something that was considered that shouldn't have been considered or something wasn't considered that should have been considered. But it must come down to law, procedure, rules, etc. Not really policy, politics, and generally not the wider picture either. There is a balance of convenience thing, which it is a fine balance, but I'll come back to that in a minute because there is a point on that. And I just, for what it's worth, I disagree with what the court said here, but I'll give you my reasons why. As I say, I'm not a judge. I just give you my views. But let's go back to this. So it is not open to the court to set aside the judge's discretion, the judgment of the High Court, just because they would disagree with it and would have done it differently. Because different judges would do things differently. And I think that's something that a lot of people struggle to get over. You could get two judges make a different decision on exactly the same case. Usually we would hope that they would come to the same decision because they follow the law and the procedure and the facts and so on. But at the end of the day, some judges might make a different decision. It goes on. Second line in here. It is our role to review that decision and only interfere with it if we identify a flaw or flaws in the judge's treatment of the question to be decided. So let's deal with that first of all. The court said they will only interfere with the judge's treatment of the question to be decided on based on error of law and so on. So let's go right back to the beginning. First of all, the American Cyanamid test for injunctions, is there a serious question to be tried? Now, in this case, is there a breach of planning law is obviously a serious question to be tried. Secondly, for the test of an injunction, would damages be an adequate remedy? Can money put things right? Well, if there's ongoing damage to the amenity of the area, then damages cannot really put that right. Thirdly, they go on to assess the balance of convenience, which is assessing the potential harm to either party. So in this case, either the migrants at the hotel or the local area, and in doing so, considering the status quo of that entire area. So that is what the court will be deciding. So it would do, the Court of Appeal would judge this based on error of law, gap in logic, or failure to take account of some material factor, which it goes on to say here. So an error of law, gap in the logic, or failure to take account of some material factor which undermines the cogency of the conclusion. So that is what the court has set out, what it can and cannot do, not just because they disagree with it, only if there's an error of law, gap in logic, or failure to take account of some material factor. But the court said then, we conclude that the judge made a number of errors of principle which undermine the decision. So let's first of all take ourselves back to the High Court judgment, just to remind ourselves of one or two things, because they'll become very important when we compare it to what the Court of Appeal said about it in just a moment. First of all, if you watched my previous video, you'll remember that the core principle here is the question as to whether or not the use of this hotel as a migrant hotel is in breach of planning laws. And as the judge noted, the High Court judge noted, there is nothing more settled than that planning law is a matter for the local authority. So they should be the one, Epping Council should be the one to decide whether or not a building is to be used for that purpose. This question is whether there's been a breach of those planning laws. And so the strength of the case is relevant, but as are many other factors. One of which being the relevance of the lawful protests about the use of the Bell Hotel as a migrant hotel. You'll see the bit in orange where it says, in addition, the fact that a proposed use will attract protest cannot without more be a ground for refusal to permit an activity which would otherwise be acceptable in planning terms. And in conclusion on this section, the bit in green here, just at the bottom before that headline bit, the judge said, the aspect of the matter is a factor which is appropriate to take into account as standing in favour of the grant of relief in the assessment of the balance of convenience, albeit a factor of limited weight. So did consider the lawful protests, but limited weight. Next, as to the unlawful activity in opposition to the use of the Bell Hotel. The judge said even if the use of the hotel were found to be unlawful, as in they shouldn't be using it as a migrant hotel, by reason it being unauthorised use material change of use would not justify the unlawful actions. Of course not. Even if it was found to be unlawful use of the hotel, that still doesn't justify the unlawful actions. That would always be the case. But the judge then summarises the bit in orange, nonetheless, account is to be taken of the impact on the amenity of the local residents of the measures taken to address the unlawful actions of those hostile to the use of the bell. The prospect that those measures, with the consequence impact on amenity, will have been taken to protect the activity by the claimant in breach of the planning control is a factor to be taken into account in determining the balance of convenience, though the weight which can be attached to it is markedly limited. So even though there is unlawful activity around and this is affecting the local amenity, the judge said, I have considered it, but it's markedly limited weight attached to considering the balance of convenience. And I'm going to come back to precisely why the Court of Appeal has criticised this in just a moment and why I think it's counterintuitive, but we'll come back to that. And then the judge went on to consider the relevance of the fear of crime, i.e. the fear of crime being generated by those in the hotel. Ultimately, the judge gives the background. You could read that and come to your own views, but the judge came to this view here. Against that background, the judge said, I'm satisfied that the fear of crime being committed by those accommodated in the bell is a relevant factor to be considered in the balance of convenience operating in favour of the grant of relief. It is, however, a factor of only limited weight. So each of those things were considered. The lawful protests, the unlawful activity, the fear of crime, they're all relevant, but only of limited weight. So ultimately, the judge was really considering the balance of convenience of, is it right to shift these migrants out, as against, is it right to allow the continuing, potentially unlawful use of the hotel? And ultimately, the judge made a judgment call and said, I side with the hotel. It should really be that the local authority should have favour here because they should decide these planning matters and the balance of convenience falls with them. And again, the argument really being that was put forward, if they can be moved in quickly, they can be moved out quickly. But now let's look at what the Court of Appeal said. But all the while bearing in mind, this really ought to be confined to this case. It should not be one of policy across the country and how does this affect other people necessarily. It should really be about this case. How is this case to be treated, this area, this question, and this particular injunction? And so with that in mind, let's take a look at what the court then said at paragraph 37. It said the wider picture, the provision of accommodation for asylum seekers pursuant to the Home Secretary's statutory duty is a national issue requiring a structured response. Yes, but that's nothing to do with the question of whether or not this particular hotel is in breach of planning laws. And secondly, not really anything to do with whether this particular hotel is having an effect on the area in that it should be granted an interim injunction to preserve the status quo of the area, not the hotel, which is where I differ in my view. You can let me know what you think in the comments if you follow that. So what we're talking about with the balance of convenience, really, who is the potential harm that we are protecting here? Is it the people in the hotel who could be moved to another hotel or somewhere else? Or indeed for the people of Epping and Epping Council to enforce its planning laws and to prevent a potential ongoing breach of those planning regulations, because it hasn't been authorised, and the question is whether they are in breach of planning laws. And just to put this in perspective, when considering the status quo and the balance of convenience here, I read that there's around 138 migrants in the hotel in Epping, as against 135 odd thousand people, according to one of the recent census, in the area of Epping altogether. So is it really better to keep the status quo for the hotel and 138 people, or 135 something thousand people in Epping? That is for you to decide and see what you think. But moving on here, the judge said that this is a national issue requiring a structured response. Now, I don't think that really ought to have been the consideration for this particular case. But again, I'm not the judge. It says here, ad hoc interim injunction applications seeking closure of particular sites may each have some individual merit. But the judge's approach ignores the obvious consequence that closure of one site means the capacity needs to be identified elsewhere in the system. Again, that is not Epping's problem. It is nothing at all really to do with this particular case, this question of law, whether this hotel has breached planning laws and whether this area should be protected because of the particular nature of what's happened there. This is very much the Home Office problem, not the people of Epping. And even this next bit is somewhat contradictory in that if the logic does apply, as the Court of Appeal says here, then it applies in reverse as well. Because if they apply this following logic in favour of the migrant hotel, the migrants in the hotel, and the balance of convenience falls with them, because the same might apply across the country, if we reverse that argument, then we say potentially this hotel is in breach of planning laws in Epping, then equally, potentially, other hotels all across the country are also in breach of planning laws all over the country, and thus affecting the amenity of local areas all over the country. The same argument works in reverse, which is, again, respectfully, a rather rudimentary principle of law. If you turn something around and you can use it both ways, it really needs to be considered like that. So reading out through from the end of the second line here, ad hoc interim injunction applications seeking closure of particular sites may each have some individual merit, but the judge's approach ignores the obvious consequence that closure of one site means that capacity needs to be identified elsewhere in the system, and may incentivize local planning authorities who wish to remove asylum accommodation from their area to apply to the court urgently before capacity elsewhere in the system becomes exhausted. Now, just if we run that back and reverse the argument a minute, if we say, well, the Court of Appeal here has acknowledged that each individual application may have some merit, in other words, other councils' applications for interim injunctions to close hotels may have merit, that may mean, if we reverse the argument, that this could mean that this obvious consequence that the Court of Appeal refers to here may also affect every other area, every other council, every other hotel that may be unlawfully being used as a migrant hotel. So yes, on the one hand, I can agree with the Court of Appeal that there is an obvious consequence that they need to find capacity elsewhere in the system. But is it really Epping's problem that the Home Office can't find them elsewhere? I don't think it is. And even if it is, then the reverse is true in that other areas across the country, other councils across the country may have a valid application for exactly the same reason, exactly the same grounds, and exactly the same argument that the hotels are being used unlawfully, but it is not their problem. It's the Home Office's problem. And so this logic just doesn't connect together for me. And furthermore, looking at this a little bit more generally, for the court to say here this may incentivize local planning authorities who wish to remove asylum accommodation from their area to apply urgently, this to me just screams, we don't want to open the floodgates. But if there is a floodgate to open, it's probably because there's a very good reason that other local authorities may wish to do so. And I think that is equally important here, not just the fact that they may apply because they also want to remove them from their hotels before capacity becomes exhausted. And finally, the Court of Appeal talked about the incentivization of protests here. Remember, which the judge at the High Court did not give much weight to, markedly limited weight, he said in some words. But it said here that whilst the judge was right to exercise considerable caution before attaching weight to the fact of the protests, including unlawful protests outside the hotel, he nonetheless gave weight in his evaluation to the fact that protests were occurring and weighed them in the balance as a factor in favour of granting the injunction. These are worrying aspects of the judgment, the Court of Appeal said. But remember, if we go back to this judgment here, each time, the relevance of lawful protests, the judge effectively said it's a limited factor. The relevance of unlawful activity, the judge said even if the use of the hotel was unlawful, it doesn't justify the unlawful actions. And nonetheless, account is to be taken of the impact on the amenity by the measures that had to be taken, but its weight that can be attached is markedly limited. But despite that wording, the Court of Appeal said these are worrying aspects of the judgment. Well, again, respectfully, I don't think they're that worrying because the judge did limit the weight that he applied to those. But then the Court of Appeal went on to say if an outbreak of protest enhances the case for a planning injunction, which it didn't really, in my view, I don't think that played heavily, but it was mentioned, but it wasn't a heavy factor. Court of Appeal said this runs the risk of acting as an impetus or incentive for further protests, some of which may be disorderly around asylum accommodation. Now, not only is that speculative and hypothetical, but the reverse, again, is true as well. If this judgment to leave it open, there is also a risk of further protest, whether that be lawful or unlawful. And for the avoidance of doubt, I strongly discourage anybody from any unlawful activity whatsoever. But then the court goes on, some of which may be disorderly around asylum accommodation. At its worst, even unlawful protests are be treated as relevant. There is a risk of encouraging further lawlessness. The judge does not appear to have considered the risk, again, perhaps because he denied himself the advantage of hearing submissions from the Home Office. But again, this logic and argument can be reversed and is equally strong in reverse. So this really is, in my view, just the Court of Appeal changing the decision, because this logic, I don't think, is strong enough to undermine the High Court judge's decision. But as it happens, and through the magic of editing, because I started this video in the morning and I'm finishing it at now about 10 to 6, now I've got home, it turns out that my argument that the logic can be reversed has been proven to be true already, sadly, because the BBC reports that the police have made 3 arrests during the Epping protest. It says 3 men were arrested during a protest outside the Bell Hotel after the Court of Appeal overturned the temporary injunction that blocked asylum seekers from being housed there. So, as I said, the logic can be reversed. The Court of Appeal essentially said, if we turf these migrants out, then there might be protests elsewhere because they think that might incentivize further action for further injunctions elsewhere, etc. But again, the logic can be reversed, and it's proven to be reversed here. The fact that the Court of Appeal has overturned this injunction has risked further outbreak of unlawful protests, sadly, which I discourage. I think it goes against the cause of the rule of law. I'm dismayed that people do this and end up getting arrested, but of course we have to look into exactly why they've been arrested and so on, so I'm not going to comment on that at all. The fact is there have been protests and people have been arrested, so that proves my point. The risk was there and the logic can be reversed. So either way, I just respectfully don't agree with the judgment. But as I always say, I'm not the judge, so that doesn't make me right. It's just a view here. I just put forward arguments, which as an advocate, that's what I do. Sometimes I put arguments forward that I don't even agree with because they might be an argument nonetheless. It doesn't matter whether you agree with something or not. You can argue for and against something, and that is the point of being an advocate, a barrister, if you will. So let me know your thoughts, comments in the box below. Please do like the video. That helps to share it with a wider audience. Subscribe to the channel. I'll be very grateful. And have a lovely evening, and I'll see you in the next one.